We can proceed.
Mr. Court pleases, today is 12 August 2025 in the Magistrates Court sitting at JP Karahi Street in the matter between the state and Emmanuel Mulunga and 14 others. Case number 854 of 2025, presiding officer, Mr. Samunzala for the state, Meili Lungwe for accused 1 and 3, Mr. Bangamavo. However, Mr. Talaya is here standing in for Mr. Bangamavo. For accused 2 and 14, Mr. Isaacs, and Ms. Ipinge is standing in for Mr. Isaacs. For accused 5, 6, 7, and 10, Mr. Namanje, and Mr. Gaib is standing in for Mr. Namanje. For accused 4, Mr. Kasper. Accused 9, Ms. Gephardt, and we are ready to proceed.
May it please your worship, I confirm appearance for applicants 1 and 2. We are ready to proceed.
May it please the court, I am standing in for Mr. Bangamabo and I am representing the fourth and the first applicant, and we are ready to proceed.
As the court pleases your worship, I do confirm my presence of accused 2 and 14. As I intimated yesterday that I stand in for Mr. Isaac Boris, who is currently engaged. Your worship, we are here for the purpose of watching brief, as the court pleases.
Please, the court, your worship, I appear for accused person number 9 in this proceeding. He is the 7th applicant in the bail application. As it pleases the court.
May it please the court, your worship, I continue appearing on behalf of accused number 4, the 6th applicant in these proceedings. May we please proceed?
Sir, you are still under oath. We can proceed.
Thank you, Worship. Now, Mr. Inambao, are you familiar with the legal concept, separate legal personality?
Well, it's self-explanatory. I'm an investigator. I'm not a lawyer.
Are you familiar with the term?
Yes, I've
with the
heard
legal
it before.
concept, separate legal personality?
I've heard it before.
Okay, thank you. You will agree with me that it is a term which accepts that a corporate entity like a company is separate from its owners, its shareholders, even its members. You accept that?
I don't accept that, provided, they are receiving gratification in this regards directly from the proceeds of an offense.
No. I think we are not understanding each other. I'm just trying to say to you, it is a concept that universally recognizes that a company is separate from its owners, shareholders, and members. That's all I'm putting to you.
Okay, I hear you.
Okay. Now, you still have Exhibit D2. That's where the charges are. Your Worship, may I ask that the court please retains its exhibits so that the court can follow. So now, Mr. Inamba, I want to suggest to you that Namcor is an entity separate and distinct from Namcor Trading.
That was established already during the investigations and during the evidence in chief.
Okay.
Even when I testified, I stated so that they are two different.
Thank you. So, and we established, Mr. Inambao, that applicant number 6 was in the employ of Namcor Trading.
That's correct.
Okay. I'd like you to have a look at page 13 of the charges. Okay. I'd like you to have a look at the alternative to count 32, right at the bottom. Would you please read that portion into the record for me?
In that between the period of 8 July 2022 and 4 May 2023, and at or near Windhoek in the district of Windhoek, the said accused did unlawfully and with intent to defraud and steal, misrepresent to Namcor that as a commercial manager she had the board approval and authority to approve the purchase 9 service stations from Enacon. Moving to page 14, Namibia Pty Ltd, and did by means of the said misrepresentation obtain from Venus Technology cash in the amount of 10,000 Namibian dollars, whereas the said accused, when she so pretended, as aforesaid, well knew that she was not entitled to receive money for her own use and benefit, and thus the accused did commit the crime of theft by false pretense.
Okay. Now, Mr. Inambao, it has been established in this court that when the state makes reference to Namcor in the charges, they are referring to Namcor, the holding company. Any comment?
I've testified all along indicating that the actual prejudice was suffered by Namcor Trading.
Mr. Inambao, before this court, it has been established that where in these charges the state makes reference to Namcor, they make reference to Namcor, the holding company.
But it's already a known fact that when we are talking about the offenses that happened, they happened within Namcor Trading and not Namcor itself.
Mr. Inambao, in this court it has been established that where the state makes reference to Namcor in the charges, they are referring to Namcor, the holding company. Any comment?
If that was established in this court, that was not when I testified.
Okay.
Maybe it was established before I started testifying.
It's fine, Mr. Inambao. So, and we have already established that applicant number 6 was not in the employ of Namcor, the holding entity.
Yes, but Namcor Trading is a subsidiary of Namcor Holding.
Which you accept by virtue of the legal concept known as separate legal personality are distinct entities from one another.
Of course.
Okay, thank you. Now, applicant number 6 did not attend any board meetings. Any comment?
I didn't testify on any board meetings.
And I'm also not saying you did. I'm going to repeat it for you. Applicant number 6 did not attend any board meetings, whether they be for Namcor, the holding entity, or Namcor Trading. Any comment?
Mr. Kaspar, I've given you my answer whether you like it or not. I didn't testify as to whether your client attended board meetings. That was never in my evidence.
Mr. Inambao, applicant number 6 did not attend any board meetings, whether they be board meetings of Namcor, the holding entity, or Namcor Trading. Any comment?
That question has been put and answered. Yes. Can we move on?
Your Worship, the question has, with due respect, not been answered.
He is on record. He's testified. He did not testify to that. That is his answer.
Indeed, Your
Whether
Worship.
you like it or
Yes.
not, it is answer.
But Your Worship, that was not my
You
question.
have repeated the question 3 times, and he answered on all occasions. It was not his evidence that applicant number 6 attended the board meeting.
Okay.
That is what he answered.
Now, Your Worship, you will equally appreciate that my question was not to suggest that he said she attended board meetings, Your Worship.
But that is his answer, Mr. Kasper. You can move on. The record speaks for itself.
Very well, Your Worship.
Yes.
Moreover, applicant number 6 made no misrepresentation to any board member, whether it be Namcor Trading or Namcor, the holding entity. Any comment?
The subsequent misrepresentation and the actual loss was suffered by Namcor Trading. Of course, Namcor Trading and Namcor Holding does have board members who are responsible for strategic directives of the institutions.
Now, also you will note that the charge we just engaged suggests, that being alternative to count 32, just so that we have the context, suggests that applicant number 6 actually stole $10,000 from Venus Technologies.
I don't know how many times I have to answer this question. The duty of drafting the charges, it's not the investigator's duty. My duty is there to gather evidence and present the evidence before the state, which will then draft the charges.
Indeed, Mr. Inambao, and I've not suggested that. But of course, you will accept that during cross-examination by Mr. Namanje, you did indicate that you assisted the state when they were preparing the charges, correct?
I provided the evidence to the state.
Okay. But in any event, the applicant number 6 denies that she in fact stole any money from Venus Technologies and that Venus is a victim in these proceedings. Any comment?
The ultimate gratification which your client received was as a result of the money that was paid by Namcor Trading to Enacon, and subsequent to that, this money was channeled or laundered via different entities, and it ended up into Venus Technology, and subsequent to that, an amount of 10,000 was paid to your client.
Okay. And applicant number 6 position is that she did not know where that money came from. All she knew was that it was Venus Technologies for whom she rendered services that paid her.
I'm sure she would have provided evidence to that effect to substantiate that in her affidavit. But what we are saying is that money was the proceeds of the money which originally came from Namcor Trading.
That's what you are saying, Mr. Inamba?
No, that's what the evidence shows.
That's what you are saying. The evidence will still be tested in a competent court of law, and it will decide whether those are proven facts or not. But let's move on. Now, Mr. Inamba, when did you commence with your investigations? I'll be happy if you give me a month and a year, if you are able to.
I've testified that the investigation commenced in 2 folds. One was in February, when the tip-off was received.
February when, sir?
2024. And secondly is when is on the 12th of June 2024, when the commission received a docket from the Namibian Police Force.
Okay. Now, how far are you with your investigations, Mr. Inamba?
Investigations are at an advanced stage, and hence we were able to identify evidence to prove offenses that has happened. Without really telling you as far as the turnaround times are concerned, but I would say that investigations are at an advanced stage.
Okay.
Just slow down.
Without suggesting a turnaround time, I'd like to know how long more or less the commission may take in the completion of the investigations. Would a month suffice? 2 months, maybe 3 months? Would you be able to give us just a suggestion?
That's a tough one for me to give you, because some of evidence which is collected, it's not in our control as to when you receive that. It's based on the stakeholders from which you are sourcing these pieces of evidence. So without me indicating the turnaround times, I would say from June last year, when the matter was reported to date, a lot of work was done. So, and I believe, given, an opportunity, the commission would ensure the investigations is finalized within the shortest time possible.
What is this opportunity, Mr. Inamba? Would it be a month? Would it be 2 months? 3 months, maybe?
That's what I cannot indicate.
Okay. All right. Now, Mr. Inamba, you have told this court that you are here to oppose bail, and it appears you are doing so indiscriminately, correct? Against all the accused persons.
As far as this application is concerned, I am here to oppose the bail in terms of the applicants.
Okay. Now, let's quickly go back to your investigations. Would it be correct that there are still suspects that the commission intends to arrest in the commission of this offense? And I don't want you to mention names. Just want you to tell us.
That's correct.
Okay. How many suspects, maybe?
I do not want to compromise the number, but we do have suspects that still needs to be apprehended.
All right. Would it be correct to assume that the commission has gathered sufficient statements from possible witnesses and witnesses?
That's correct.
Okay. Would it also be correct that the commission has been able to obtain the necessary bank statements from the financial institutions?
That's correct.
Okay. Is there any international assistance that the commission has sought, perhaps, through the Ministry of Justice or international relations?
We haven't formalized that, but as far as investigations is concerned, we are also looking outside the boundaries of the Republic of Namibia.
All right. You accept that when that happens, that would be a process between the Prosecutor General's office or the Commission and either the Ministry of Justice or international relations, correct?
Of course.
Okay. Now, Mr. Inamba, you are aware that all people are equal before the law, correct?
It's correct.
Okay. You are equally aware, Mr. Inamba, that there has been no blanket refusal of bail concerning this matter, correct?
I can't say correct. We are here in order for the court to make that determination based on the merits of the case.
Okay. Let's put it this way, Mr. Inamba. Mrs. Elindi, who was in the accused person's dock, has been granted bail on bail consideration, correct?
That's correct.
Okay. Mr. Connie van Wyk has been granted bail on bail consideration, correct?
That's correct.
Okay. So the state does not indiscriminately oppose to bail, taking a blanket approach.
I would say so because one has to look at, the roles that each of the individuals, involved played during the perpetration of the offenses in question.
Just for completion, or the sake of completeness, what are the conditions and bail consideration that was imposed against Mr. Connie van Wyk?
I'm not at liberty to say what was the conditions that was imposed. We can simply get the court record and see what.
So would it be correct to say that you don't know? Is that what you're saying?
It's not that I don't know.
Okay, then if you do know, please tell us what those conditions are, Mr. Inambao. May I just remind you, Mr. Inambao, that you are a witness for this court and you are here to assist this honorable court.
Mr. Connie reports 2 days a week.
Okay.
And surrendered his traveling documents.
What was the bail amount he paid?
But you know the amount already.
Mr. Inambao, what was the bail amount he paid?
And I'm saying you know the amount already.
Mr. Inambao,
Just answer the question if you do, so that we can.
50,000, Your Worship.
are there any further conditions that were imposed?
At this point in time, I've given you the other conditions which I'm privy to, but of course the others come standard, like no interference with investigations and so forth and so on.
And these conditions were imposed with your guidance. You guided the state as the investigating officer who's concerned with his investigation on suitable conditions that will safeguard that concern, correct?
Not entirely correct.
Okay. Now give us that part that is correct and leave out the part that is not correct.
Remember, I was here testifying on Friday when the bail was granted.
I know, Mr. Inambao.
So
We were in the same court.
yes, we were in the same court. I was not in that court, so I don't know what considerations were used.
But you said partially. So I'm just interested in the partially part. You can
No,
disregard.
you asked me on the conditions which are there, and I know the conditions because of the court order, but I was not part and parcel of the consideration. So I don't know why we should even go there, because I'm telling you I was not there.
But you agreed with me and you said partially. That's the only reason why I'm exploiting that.
Okay, but I've given you an answer.
Now, Mr. Inambao, you know that, are you in possession of the charges that Mr. Van Wyk is facing? But anyway, you may probably not have them there. Let me put it to you differently. Are you aware that he's accused of concealing and receiving gratification in the amount of 1.5 million Namibian dollars?
I'm aware of that.
Okay. You agree that there is a considerable amount as opposed to a mere 10,000 that applicant number 6 is alleged to have received?
I don't know why we are making references to an application which is not before this court.
Mr.
But
Inambao,
your client was in an official capacity which resulted in her authorizing the supply of fuel to Erongo, specifically Erongo, to their value of 238 million, which is way more than the 1.5 that you are talking about.
Mr. Inambao, I'm going to repeat the question to you. The amount of that was concealed and that was alleged to have been received as gratification is 1.5 million Namibian dollars.
That's correct.
An amount considerably higher than 10,000 Namibian dollars. Would you agree with that?
But it's a common cause. 10,000 versus 1.5, they are not the same.
And that's the thing, Mr. Inambao. It's quite common cause. It's simple. It's straightforward. Yet you have difficulty answering it.
No, I'm telling you, in terms of your client, he was an employee of Namcor Trading. Subsequent to her employment relationship, she authorized fuel above the credit limit to the value of 238 million.
It's common cause, it's straightforward, yet you have difficulty answering it. That's the bottom
I've
line.
given you my answer.
And despite the fact that you have a song about conspiracy and suggesting that the accused persons conspired to commit the offense.
In fact, it's good you are talking about it, because you can see the charges are different. There's conspiracy for your client, which dates back as far as July 2022. And the supply of fuel continued until 2023.
Yeah, Mr. Inambao, of course, those are issues that are denied. So I'm not even going to engage with you on those. Let's move on. Now, Mr. Inambao, as an investigating officer who is concerned about your investigations, you have a duty to assess this court in the event that this court may impose certain conditions to guide this court on what appropriate conditions would best serve your concerns with your investigations. Do you agree with that?
I'm here to inform this court on the seriousness of the offense, on the evidence that the commission has gathered, and the reason as to why the state is objecting to the bail. As far as the conditions thereof, it will be the duty of the court. But we are saying, among others, the fear which is there is interference with investigations, the complex transactions involved in money laundering, and so forth and so on.
Okay. Now, that's why I'm saying, Mr. Inambao, as an investigating officer concerned about your investigation, you have a duty to assess this court in making proper bail conditions that will safeguard your concerns.
I've answered the question.
Okay. Now, you are concerned with interference, Mr. Inambao, correct?
Among others.
Okay, amongst others. Do you have any evidence that suggests that applicant number 6 has interfered or has attempted to interfere with your investigations?
I testified yesterday or during cross-examination. I don't think the people were aware that they were ever going to be arrested.
Mr. Inambao,
the charges are serious and the risk of interference is high.
Mr. Inambao, I'm going to repeat the question. Do you have any evidence that suggests that applicant number 6 has interfered or has attempted to interfere with the investigations?
Although we are not able to point at that, the risk remains the same.
And the risk also... Now I put it to you, Mr. Inambao, in respect of... Oh, sorry, Your Worship. In respect of applicant number 6, Mr. Inambao, I put it to you that that risk does not exist.
You were never employed by Namcor Trading. You don't know the parties that are involved.
Can you please guide this witness, Your Worship?
Can you just answer the question?
Thank you.
Yes. Counsel is only here on instructions of his client or her client. He is not putting those because they are coming from him. It is his or her client's instructions. Yes.
Thank you, Your Worship.
Yeah.
The accused person worked at Namcor Trading, where most of the witnesses who would be testifying or providing evidence in this matter, and she knows them.
Mr. Inambao, first of all, the applicant has long since ceased to work for Namcor Trading. You agree with that?
I agree with that, okay. But it does not mean that she does not know the people anymore.
Mr. Inambao, further, applicant number 6 does not know who the witnesses in this matter are. They have not been disclosed to her. Correct?
As I said, she worked there. When she was authorizing these transactions, she knew to whom she was sending these transactions, the authorization.
Mr. Inambao, did you disclose to the accused persons who the witnesses in this matter are?
No.
Okay. Applicant number 6's position is that she does not know who the witnesses are. You have not disclosed who the witnesses are, as per your own admission.
I've answered the question already, Your Worship.
Now, it is applicant number 4's position that she intends to stand trial and to demonstrate her innocence. She does not want to run away.
Your Worship, I cannot confirm that. All I know is we could not have an address, a fixed address for applicant number 4. At the time we were looking for her.
Applicant number 4.
Now,
Applicant the
Oh.
problem only because Mr. Casper, you referred to applicant number 4.
Sorry, it's a slip of the tongue, Your Worship. Applicant
Yes,
6.
number 6.
Yes.
But we are referring to applicant number 6.
thank you, Your Worship.
Yeah.
Yes.
Okay.
So there is no way the state can guarantee that. As far as we are concerned, Your Worship, the charges are serious in nature. The value is very high. And this is not 1 or 2 charges. This is charges which stems from conspiracy to fraud, corruption, and money laundering.
Okay.
The nature of these transactions are so complicated. And it's not to say, Your Worship, because we were able to connect only an amount of 10,000, that there is no other payments.
And
that's why we are saying we are still investigating.
And Mr. Inamba, we have demonstrated to you that these charges can best be described as chaotic and they hold no merit.
That is your position. As far as the evidence that we have gathered during the investigation, we are confident that offenses in this regards were committed.
Okay. Now, Mr. Inamba, you have Exhibit F with you. That is the application by applicant number 6.
I think you took it back yesterday. You did not wanted me to use the one from the prosecution.
For obvious reasons. We'll assess you shortly. In fact, you can use this one. It's fine. I just want you to read. Yes. Paragraph 1 into the record. But let's just wait so that Your Worship is with us.
Paragraph 1 of the affidavit.
Yes, Your Worship.
You can proceed.
I'm a major female, Namibian national with Namibian identity number 812-11-023-7. I ordinarily reside at number 17 Northern Valley, Ambrose Street, Glencoupe, Windhoek, Republic of Namibia.
Okay. Can you please return that? Thank you. You see that, Mr. Inamba? That is her address. And I want to put it to you further that the commission never sought to visit applicant number 6 at her place of residence, but instead opted to call her in, which she complied with.
Your Worship, that statement is totally incorrect because as far as the records are concerned that we could retrieve of applicant number 6, one of them was for an Olivia estate somewhere in these areas. Another one was one of the other suburbs. In fact, we had to use the next of kin in order to reach applicant number 6. In fact, that affidavit says ordinarily resides there, meaning at times she's not residing there.
Mr. Inamba, the commission did not search for the applicant at her place of residence. The commission instead opted to call her, and she complied by presenting herself.
Your Worship, as I indicated, we searched various sources, various databases, and the addresses known. The addresses that she used, Your Worship, she was no longer residing there.
Let's do it this way. How did you apprehend applicant number 6, Mr. Inamba?
I've indicated we had to call the next of kin. And then through the next of kin, we managed to reach, we managed to get the number of applicant number 6. And then eventually we spoke to her.
And then?
That's when she came.
Exactly. That's the bottom line, Mr. Inamba. She did not run away from you.
Because she did not know that we were coming to arrest her.
She presented herself to the commission when she was requested to do so, Mr. Inamba. And that is something that counts in favor of applicant number 6.
But she did not know she was going to be arrested.
Mr. Inamba, we can see that you are openly and nakedly hostile and biased in evidence you tender before this court in relation to the accused person. You are not even willing to give this court something that is in favor of the accused persons. That's what we will argue.
It's within your rights to argue that. I'm telling you what happened as far as during the investigations or on the day that your client was arrested. I'm telling you as far as the sources that that we could retrieve known addresses from. We couldn't find that as a listed address.
Mr. Inambao, further, applicant number 6 says that if she is presented a list of witnesses not to interfere with, she will oblige such a request. Any comment?
As I indicated, the seriousness of the offense, the value that is involved, these are serious charges. You know, I mean, if she was able to conspire to commit these offenses,
Mr.
I mean,
Inambao,
she can
please.
still conspire also to compromise the witnesses.
Mr. Inambao, no offense has yet been committed. Your evidence still needs to be proven before a competent court of law. So please leave those arguments. I don't want to argue with you.
But I'm here to testify on the evidence that we gathered during the investigations, which resulted in the formulation of the charges, which among others includes conspiracy.
Very well, Mr. Inambao. That is evidence you have gathered. We will thoroughly put that evidence to the test when the trial comes. But I am putting to you that applicant number 6, if she is presented a list of witnesses with whom she should not interfere, will oblige by such a request. Any comment? And I'm not interested in your long stories of serious charges. We have already demonstrated
That is a high risk.
They are pathetic charges.
Giving your client a list of witnesses when we already have charged there on conspiracy.
In any event, even if there is no list of witnesses presented and she is told not to interfere with witnesses, she will oblige to such a request. Any comment?
There's no way we can guarantee that. So, and what I'm saying is I'm here to oppose bail, meaning part of any reason I'm here is to indicate that the state, or rather the commission, gathered evidence and we have a strong case, and therefore we are opposing to bail because one of the suspects is currently AWOL.
Mr. Inambao, you can only wish to have a strong case. We have already demonstrated how pathetic and chaotic the charges are. You have agreed with us. We have pointed you to the charges. You were crying here that the state did not have sufficient time. They were put under pressure. Those are the preliminary charges you are referring to.
I think since yesterday, you have demonstrated elements of disrespect where you use the word nonsense, and now you are using pathetic. So if I use the same words to you,
Your Worship,
I don't think that would be proper.
Your Worship, would you please guide this witness?
Please just answer the question.
Your Worship, how do I answer a question if the case is pathetic?
That is his version. You know why you are here. You just answer the question.
It's English, Your Worship.
Your Worship, we have demonstrated through evidence that we have a strong case. So in your view, there is no strong case, but the accused persons would not be before court if there was no case.
Further, Your Worship, sorry, Mr. Inambao, if the applicant is ordered to report herself at whichever station, whether it be twice or 3 times a week, she will oblige such a request. Any comment?
I don't have a comment.
Okay.
I stated
Then let's
already
move
my
on.
reasons.
You don't have a comment? Let's go on. Thank you. Further, she is able to pay 10,000 Namibian dollars in bail consideration. Any comment?
No comment.
Okay,
I mean,
thank you.
I'm
Let's move
saying
on.
we are here to
If you have
object.
said you have no comment, Mr. Inambao, we can move on.
Yeah.
Thank you. Also, it is applicant number 6 position that the granting of bail to her would not put public interest or the administration of justice in disrepute. Any comment?
Definitely the opposite, to put the public's interest in disrepute. I'm sure the public is concerned about what is happening. The nature of charges she's facing, they are very serious.
Mr.
Amounts
Inambao?
that are involved,
Yes.
they are It's high amount.
Okay, we have already demonstrated that these charges are chaotic. We have also demonstrated that this meager $10,000 she's accused of receiving is a drop in the ocean.
You are the only one that looks at it as a drop in the ocean.
Your Worship, can you please guide this witness? I can also do that. And this court has a duty to call this witness to order. It's not my case. It's also not your case, Mr. Inamba.
Just come here. Mr. Inamba, just simply answer the question. Yes.
Thank you, Your Worship.
Yes.
Your Worship, from where I'm standing, the amount of 10,000 might look insignificant, but it's the conduct that we are looking. If somebody was able to receive an amount of 10,000 Namibian dollars in order to process the supply of fuel to the value of 238 million, Your Worship, that is what we are concerned. In fact, when we are talking about corruption, Your Worship, we are not putting a figure. We are talking about the conduct. If a person was able to do this for $10,000.
And Mr. Inamba, none of these allegations are proven before any competent court of law. You agree? None of these allegations are proven before any competent court of law. Your evidence is still to be tested, Mr. Inamba. And the accused persons are to be presumed innocent until proven guilty.
Although the evidence is still to be tested, we have demonstrated what happened. Through
He is not finished.
No, yes, Your Worship, I realized he's still singing.
through the evidence or through the investigations that was conducted, Your Worship. Evidence was gathered. She, with her colleagues, approved the supply of fuel.
Mr. Inamba, at the trial and commencement of trial in these proceedings, applicant number 6 will plead not guilty to all the charges, and the state will be put to prove its case beyond a reasonable doubt. Any comment?
It's within her rights to plead not guilty, and the state, of course, will present the evidence that was collected in order to inform the court as to what really happened. And it will be the duty of the court to determine as to whether she's guilty or not.
Amen. Thank you. You are coming around. Your Worship, that's my cross-examination. The court, please.
Yeah, sure.
Your Worship, may I just request that we take a brief 5-minute health break so that my colleague can also just set herself up here?
And the court takes 10 minutes.
Yes, the court, please.
You were doing yesterday. That's how you do it. Yeah.